It is past midnight on a dirt road in the Colorado Rockies, and a young man is making a heart shape with his hands. He presses them against the inside of his car window, fingers laced, palms facing out, and holds the shape toward the officers, standing in the dark outside. His name is Christian Glass. He is 22 years old. He called 911 2 hours ago because his SUV got stuck in the mud and he needed help. Now 7 law enforcement officers from 5 different agencies surround his car. He has committed no crime. He has hurt no one. He is blowing kisses at the officers. He is praying out loud. He is terrified. In a few minutes, one of those officers will break his car window. Christian will reach for a geology knife, the kind he used to crack open rocks. And then he will be shot 6 times. The coroner will rule his death a homicide. This is not a story about a split-second decision in a dark alley. This is a story about what happens when a system designed to help people chooses instead to treat a frightened young man in crisis as a threat to be neutralized. By the end of this video, you will know exactly what the law says about what happened here and what actually happened to Christian Glass after the cameras stopped rolling. The 10th of June, 2022. A Friday night. Christian Glass is driving home from a geology trip in Utah, winding through the mountains toward Boulder, Colorado, when his SUV slides off a dirt road and buries itself in mud near Silver Plume, a small former mining town in Clear Creek County, population under 200. He cannot get the car free. It is late. He is alone in the dark. At approximately 11:20 p.m., Christian calls 911. During the call, which will last nearly 25 minutes, he tells the dispatcher something important. He has tools in the car. 2 knives, a hammer, a rubber mallet. They are geology tools, but he understands how they might look. He says he will throw them all out of the window the moment officers arrive. He also says something else. He is afraid of skinwalkers' figures from Navajo tradition, and that he does not feel safe leaving the vehicle. His voice is anxious, urgent, and strange. The dispatcher stays on the line. Deputies are coming. Deputy Andrew Buen and Deputy Tim Collins arrive first. More officers follow. Over the next 70-plus minutes, personnel from 5 agencies assemble on that dirt road. The Clear Creek County Sheriff's Office, the Idaho Springs Police Department, Georgetown PD, the Colorado State Patrol, and 2 investigators from the Colorado Division of Gaming. 7 officers in total. They have lights, they have weapons, they have numbers. What they do not have is a crisis intervention specialist. What they do not have is anyone trained specifically to de-escalate a mental health episode. What they do have is body cameras, and those cameras will record everything. Inside the car, Christian is growing more frightened, not less. He does not exit. He speaks to officers through the cracked window. At one point, he prays aloud, "Dear Lord, please don't let them break the window." At one point, he makes a heart shape with his hands and holds it against the glass. At one point, he blows kisses. Sergeant Kyle Gould, the supervising officer, is not on scene. He is monitoring the situation by phone. He makes a decision, break the window, and extract glass from the vehicle. He authorizes Deputy Buen to do it. A Colorado State Patrol supervisor, listening on the radio, questions the call in real time. The recorded audio captures this supervisor asking, "If there's no crime and he's not suicidal or in grave danger, then there's no reason to contact him." No one listens. Officers approach the window. The glass shatters. Christian Glass, trapped, terrified, and now suddenly exposed, grabs one of the geology knives he had promised to surrender hours earlier. Officers deploy beanbag rounds. A taser. Neither stops him from holding the knife. Deputy Buen fires. Multiple rounds. 6 bullets strike Christian in the torso and upper right arm. Christian Glass dies at the scene in the early morning hours of the 11th of June 2022. He was 22 years old. He had called 911 for help. What he got, and why, is a story that will take a jury, 2 trials, and 3 years to fully reckon with. Christian Glass did not fit easily into a category, and that was part of what made him who he was. He held citizenship in 3 countries, the United States, New Zealand, and the United Kingdom. His parents, Simon and Sally Glass, had moved the family from New Zealand to the U.S. when Christian was a child, and he grew up in Boulder, Colorado, a university town at the foot of the Flatirons, where the mountains begin. He was 22 years old when he died. He had been diagnosed with ADHD. His family says he also struggled with depression. He was, by all accounts, a young man who felt things intensely and who channeled that intensity into things he loved. He loved rocks, not casually. Not as a hobby he had picked up and might put down. Christian was an amateur geologist in the truest sense. Someone who spent time in remote places, studying the earth, cracking open stones to see what the world had hidden inside them. The hammer and rubber mallet that officers would later see as threatening items were geology tools. The knives were pocket tools for the field. The trip he was returning home from when his car got stuck was a geology trip to Utah. He was also an artist. These two things, scientist and artist, rock collector and creator, are not as different as they sound. Both require patience. Both require a willingness to look at something ordinary and see what other people miss. Both require a kind of solitude that most people find uncomfortable. On the night of the 10th of June 2022, Christian was alone in the mountains, in the dark, in a stuck car, and he was frightened. His family would later describe what happened in that car as a mental health episode. His behavior on the 911 call the fear of skinwalkers, the refusal to leave the vehicle, the mounting distress is consistent with that characterization. Whether it was triggered by his depression, by anxiety, or by something else entirely, what is not in dispute is this: he was not a threat to anyone. He was a young man in crisis, reaching out for help through the only channel he knew. He called 911. His parents, Simon and Sally Glass, would spend the years after his death fighting for accountability with a persistence and dignity that became its own kind of testimony to who their son was. They became advocates. They pushed. They showed up. They refused to let the official narrative, which initially described Christian as argumentative and armed, be the last word. They were right not to accept it. Christian Glass was a two-year-old, with rocks in his car and art in his hands and a phone number dialed to the people he thought would help him. He pressed his hands against the window in a heart shape. That image captured on body camera, played in a courtroom, seen by the world, is the image that matters most. Not because it is dramatic, because it is true. That is who Christian Glass was. And now we need to talk about what the law says about what was done to him. Start with the Fourth Amendment to the United States Constitution. It protects Americans against unreasonable seizures. The use of deadly force against a person is, legally speaking, the most extreme form of seizure possible. The government is stopping you permanently. In 1985, the U.S. Supreme Court decided Tennessee v. Garner. That case established a rule that still governs every law enforcement officer in this country. Deadly force is only constitutionally permissible when an officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to officers or others. Not a theoretical threat. Not a possible threat. A significant, imminent, real threat. Now, layer on Colorado state law. In 2021, following the killing of Elijah McClain, Colorado passed Senate Bill 21-217, known as the Law Enforcement Integrity Act. This was one of the strongest police accountability laws in the country at the time it was enacted. It required officers to intervene when they witnessed another officer using excessive force. It required force to be necessary and proportional. And crucially for this case, it made failure to intervene a criminal offense, not a policy violation. A crime. Colorado also passed House Bill 21-1250 as part of the same reform package, which codified de-escalation requirements for law enforcement. Officers are legally required to attempt de-escalation before using force when circumstances allow. Officers had every right to respond to Christian's 911 call. They could approach the vehicle, they could speak with him, they could attempt to de-escalate for as long as necessary. If Christian had posed a clear, imminent threat of serious bodily harm, and if they had genuinely exhausted all de-escalation options then limited, proportional force might have been legally on the table. But here is what actually happened. Christian had committed no crime. He was sitting in a stuck car. He was frightened and in crisis. But he was not threatening anyone outside the vehicle. The grand jury, the group of citizens who reviewed all the evidence and decided whether to indict, found explicitly that Christian Glass did not pose a danger to officers or to the public. The supervising officer, Sergeant Kyle Gould, was not on scene. He authorized the breach of Christian's car window over the phone, without witnessing Christian's behavior directly and without a legal basis to do so. A Colorado State Patrol supervisor, present at the scene, listening on radio, flagged the decision in real time. No crime had been committed. The entry was not justified. When the window broke and Christian grabbed a knife he had offered to surrender hours earlier, Deputy Buen fired. Not because an attack was in progress, because he had just created, through an unlawful entry, the conditions for one. A lawful version of this encounter does not end with 6 bullets. It ends with Christian Glass alive. Officers maintain a perimeter. They keep talking. They wait. If a crisis intervention co-responder is available, they call one in. They do not breach the vehicle without a legal basis. They de-escalate. They give Christian time to become less frightened, not more. That is not idealism. That is the law. The law is not ambiguous here. Christian Glass died on that dirt road. By the time the sun came up, over Clear Creek County, on the 11th of June 2022, his parents did not yet know what had happened to their son. They would find out, and then they would learn what the Clear Creek County Sheriff's Office chose to say about it. The department's initial press release described Christian as having immediately become argumentative and uncooperative when officers arrived. It stated that he had armed himself, a phrase that conjures the image of someone preparing to attack, not a frightened 2-year-old, clutching a geology knife inside his own car after officers broke his window. This was the official story. A dangerous, uncooperative individual who forced officers' hands. The body camera footage told a different story. Clear Creek County Undersheriff Bruce Snelling defended the use of force in September 2022, more than 3 months after the shooting. In public statements, the department maintained that its officers had acted appropriately given the circumstances. Meanwhile, Christian's parents, Simon and Sally Glass, had seen the footage. Attorneys had seen it. And as the recordings became more widely known, showing Christian making a heart shape at the officers, blowing kisses, praying, saying please, the gap between the official narrative and the recorded reality became impossible to paper over. The footage was not suppressed indefinitely. It was released, and it traveled. News organizations ran it. People watched a young man in obvious distress being described by the institution that killed him as a threat who had armed himself. Governor Jared Polis met with the Glass family. He stated publicly that the tragedy should never have happened. That is a notable thing for a sitting governor to say about officers still employed by agencies in his state. But statements from governors do not indict anyone. That requires a grand jury. In November 2022, 5 months after the shooting, a grand jury handed down indictments against Deputy Andrew Buen and Sergeant Kyle Gould. Buen was indicted on second-degree murder, criminally negligent homicide, reckless endangerment, and official misconduct. Gould was indicted on criminally negligent homicide and reckless endangerment for his role in authorizing the window breach from off-scene. Both were fired from the Clear Creek County Sheriff's Office. It did not stop there. A year later, in November 2023, District Attorney Heidi McCollum charged 6 additional officers with failure to intervene under Colorado's Law Enforcement Integrity Act. The law that made standing by while a colleague used excessive force a criminal offense. Those 6 officers came from 4 different agencies. They had all been present on that dirt road. They had all watched. The institutional response was not uniform. Colorado State Patrol Chief Colonel Matthew Packard stated publicly that he was shocked by the charges against Trooper Ryan Benny and found no policy violation in Benny's conduct. Idaho Springs Police Chief Nathan Busek defended Officer Brittany Morrow. These were not the responses of institutions reckoning with failure. These were institutions circling wagons. The wagons, it would turn out, would not hold. The fight for accountability in Christian Glass's case did not happen in a single courtroom. It happened on multiple fronts simultaneously, and it required the Glass family to sustain it for years. Simon and Sally Glass became the public face of that fight almost immediately. They did not retreat into grief and silence. They gave interviews. They demanded transparency. They challenged the official narrative in real time, and they did so with the clarity of people who had seen the body camera footage and knew what it showed. Their attorneys filed a civil lawsuit against the state of Colorado, Clear Creek County, and the municipalities of Georgetown and Idaho Springs. The complaint alleged violations of Christians' constitutional rights and named multiple agencies and officers as defendants. It was a sweeping legal action, and it put direct financial pressure on every institution that had sent officers to that dirt road. In May 2023, less than a year after the shooting, the parties reached a settlement. The amount was $19 million. It was, at the time, the largest police killing settlement in Colorado history. But the Glass family did not accept $19 million and walk away. They negotiated conditions. The settlement required Clear Creek County to establish a crisis intervention co-responder program so that the next time a call came in with mental health dimensions, a trained specialist would go to the scene, not just officers with guns. It required de-escalation training for all deputies. It required the Colorado State Patrol to develop a statewide virtual reality training scenario based specifically on the Glass shooting, so officers across Colorado would train on what went wrong that night. It required government buildings to display Christian's artwork. It required a public park to be dedicated in his name. These were not symbolic gestures. These were structural changes, written into a legal agreement, backed by the force of a court settlement. On the criminal side, the fight was longer and more complicated. Buen's first criminal trial on the murder charge did not go as prosecutors hoped. The jury convicted him on reckless endangerment, but on the second-degree murder count, they deadlocked. One juror held out. One juror was enough to deny a murder conviction. District Attorney McCollum did not accept that as a final answer. She took Buen to trial again. On the failure to intervene charges against the 6 additional officers, the legal picture was also complicated. The charges were serious and unprecedented. Rarely does a district attorney in Colorado charge 6 officers from multiple agencies with a crime for failing to stop a colleague. These charges represented the Law Enforcement Integrity Act being used at its full statutory potential for the first time in a case of this magnitude. Attorneys for the officers challenged the charges. Some of those challenges would ultimately succeed. But the fight, the willingness of a prosecutor to bring these charges at all, sent a message that reverberated through Colorado law enforcement. Standing by is not neutral. Standing by has consequences. The question of whether those consequences would be sufficient was still being written. Here is what actually happened. Andrew Buen's first trial concluded in April 2024. The jury convicted him of reckless endangerment. On the second-degree murder count, they could not reach a verdict. One holdout juror hung the jury. Buen did not go to prison that day. DA McCollum retried him. In February 2025, a second jury convicted Andrew Buen of criminally negligent homicide. On the 14th of April 2025, Judge Catherine Chirutes sentenced Andrew Buen to 3 years in prison, the maximum sentence available under the conviction. In her remarks at sentencing, Judge Chirutes stated explicitly that the incident was about power, not a reasonable mistake. She did not characterize what happened as a tragic accident made by officers doing their best. She called it what the evidence showed it was. At the same sentencing, State Prosecutor Stephen Potts told the court that body camera footage from the glass shooting is now used nationally as a training example of what not to do. Christian's death has become a teaching moment in law enforcement academies across the country. Buen also lost his Colorado Peace Officer Standards and Training certification, his post license, permanently barring him from working as a law enforcement officer in Colorado again. Kyle Gould, the supervising sergeant who authorized the window breach by phone without being on scene, pleaded guilty in November 2023 not to criminally negligent homicide as originally charged, but to the lesser misdemeanor of failure to intervene. He was fired from the sheriff's office and his post-certification was revoked in 2024. He will not work as a law enforcement officer in Colorado again. Tim Collins, who was first on scene alongside Buen and charged with failure to intervene, resigned from Georgetown PD. His criminal charges were dismissed by Judge Cynthia Jones in May 2025. Brittany Morrow, of the Idaho Springs Police Department, also charged with failure to intervene, had her charges dismissed in May 2025. Ryan Benny, of the Colorado State Patrol, charged with failure to intervene, had his charges dismissed in May 2025. The final legal dispositions of the failure to intervene charges against Georgetown Police Marshal Randy Williams and Colorado Division of Gaming investigators Mary Harris and Krista Lloyd were not confirmed in available sources. At the time this script was prepared. Those cases may still be active. We will update this video if and when those outcomes are confirmed. The civil settlement, $19 million, reached in May 2023, stands as the largest police killing settlement in Colorado history. The structural conditions attached to it, the co-responder program, the de-escalation training, the VR scenario, the park, the artwork are legally binding. Simon Glass spoke at Andrew Buen's sentencing. He said, "Christian's name has now finally been cleared." That sentence carries everything. His son was called argumentative, armed, dangerous, a problem to be contained. His name has now been cleared. Christian Glass's case is not a statistical outlier. It is a data point in a pattern that researchers, public health officials, and civil rights organizations have been documenting for years. People in mental health crisis are significantly overrepresented in fatal police encounters in the United States. Estimates from researchers and advocacy groups have consistently placed the figure at roughly 25 to 50% of all people killed by police each year. People who were experiencing some form of mental health episode at the present time of the encounter. The range varies depending on methodology, but the direction is consistent. A disproportionate share of those who die in police shootings are people who needed mental health intervention, not a tactical response. The mechanism is straightforward. Police departments are, historically, the default responders to everything. Mental health crisis. Domestic dispute. Someone in distress on a road. The 911 system routes calls to law enforcement not because officers are the best equipped responders for every situation, but because they are available around the clock and they go everywhere. Christian Glass called 911 from a dirt road at 11:20 p.m. on a Friday night. There was no one else to call. There was no mental health crisis line that dispatched trained clinicians to remote mountain roads. There were only police. The Colorado Reform Legislation of 2021, Senate Bill 21-217 and House Bill 21-1250 was passed specifically because the state legislature recognized this gap after the killing of Elijah McClain in Aurora in 2019. McClain was a 3-year-old massage therapist walking home from a store when officers stopped him without cause. He died after being placed in a carotid hold and administered ketamine by paramedics. He was not armed. He had not threatened anyone. He too had been in some kind of emotional distress. Colorado legislators responded by creating mandatory de-escalation requirements, mandatory intervention duties, and criminal liability for failure to intervene. They built the legal infrastructure to hold officers accountable, not just administratively through termination and decertification, but criminally. The Glass case was the first major test of that infrastructure at scale. 8 officers charged. Multiple agencies involved. A district attorney willing to use the statute as it was written. The results were mixed. Buen was convicted and is going to prison. Gould pleaded guilty and lost his career. But the failure to intervene charges against Collins, Morrow, and Benny were dismissed. The judge in those cases found the legal standard had not been met for criminal liability. That outcome tells us something important. The infrastructure exists, but it has limits. Criminal prosecution for failure to intervene is legally complex. The burden of proof is high. Juries and judges apply it case by case. What did change, structurally, is the civil settlement, the VR training scenario, the co-responder requirement, the precedent of a $19 million judgment that will make every county in Colorado think twice before deploying 7 armed officers to handle a mental health crisis with no specialist in sight. Christian Glass is not the first person to die this way. He will not be the last. But his case moved the law forward. The question is whether the law moved far enough. Accountability is not a single event. It is a series of decisions made by institutions over time that either reckon honestly with failure or do not. In the Glass case, some institutions reckoned. Others did not. Clear Creek County fired Buen and Gould. Their post-certifications were revoked. They will not work in law enforcement in Colorado again. That is accountability with teeth. But the Colorado State Patrol's chief went on record saying he was shocked by the charges against his trooper. The Idaho Springs police chief defended the officer on scene. These were institutional postures of denial, the same posture that produced the original press release calling Christian argumentative and armed. The charges against those agencies' officers were ultimately dismissed. Whether that is justice or a failure of justice depends on what you believe the law is supposed to do. The judge found the criminal standard was not met. But the standard is set by the legislature. The legislature wrote the Law Enforcement Integrity Act. The question of whether it is written strongly enough is a legislative question, one that Colorado lawmakers can revisit. Here is the mechanism. SB 21217 requires an officer to intervene when they observe a fellow officer using unlawful force. But the burden of proof beyond a reasonable doubt is high in criminal proceedings, and courts interpreting these cases for the first time are establishing precedent in real time. The Glass dismissals are part of that precedent. They tell prosecutors, defense attorneys, and legislators what the statute's actual reach is, as opposed to its intended reach. The $19 million civil settlement imposed structural changes. Those changes are legally binding. The co-responder program for Clear Creek County, the requirement to send a mental health professional alongside or instead of officers in appropriate situations, is the most direct response to what went wrong on that dirt road. It acknowledges, in legal writing, that what Christian Glass needed was not 7 officers. He needed someone who understood what was happening to him. What did not happen? No officer on scene served a single day in custody for failing to intervene. No senior leadership figure above Gould faced criminal consequences for the culture or training that produced that night. The agencies that defended their officers publicly, despite the body camera footage, despite the grand jury, despite the convictions, faced no institutional sanction beyond the civil settlement. Buen is going to prison. Gould lost his career and pleaded guilty. The civil settlement has teeth. Those are real outcomes, and they are rarer than they should be. But the system that put 7 officers on that road with no crisis specialist, that produced an initial press release designed to justify the unjustifiable, that had supervisors publicly defending their officers weeks after the footage showed what actually happened, that system is still largely intact. Accountability reached some people. It did not reach the system. Partial justice. Andrew Buen is in prison. Kyle Gould lost his career. Colorado changed its law. A $19 million settlement rewrote policy. But Christian Glass is gone. The system that sent armed officers to handle a mental health crisis with no specialist, no plan, and no exit is still running. Justice here is a floor, not a ceiling.